Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court began historic hearings in the matter of marriage equality. Supreme Court Constitution Bench comprising of CJI Chandrachud, Justice Sanjay Kishan Kaul, Justice Ravindra Bhatt, Justice Hema Kohli and Justice P.S. Narasimha heard a batch of petitions seeking the legalization of same-sex marriage. The court said that there is no data to show that same-sex marriage is an elitist concept while picking up holes in the centre's contention that petitioners seeking same-sex marriage rights is a mere urban elitist view for the purpose of social acceptance. The top court stressed that the state cannot discriminate against an individual on the basis of characteristics over which the person has no control, and something which is innate cannot have a class bias. Senior advocate Abhishek Manu Singhvi, appearing for petitioners, laid down the heart of the issue, which he described to be the right to choose and the discrimination based on descriptive characteristics. He added that a person's sexual orientation is intrinsic, it is connected with their individuality and identity. A classification which discriminates persons on their innate nature would be violative of their fundamental rights and cannot withstand the test of constitutional morality. Mr. Singhvi emphasized that the most important is a discriminatory exclusion of the classes on only sex and sexual orientation, and added that the marital status is a gateway to the legal and civil benefits such as tax benefits, inheritance and adoption. The top court has significantly remarked that by decriminalizing homosexuality, one cannot contemplate that the persons who belong to the same sex would be in stable marriage-like relationships. The Supreme Court has held that the lack of jurisdiction of a court to entertain a complaint can be no ground to order its transfer. The division bench of Justice V. Ramasubramanian and Justice Pankaj Mittal observed that the question of territorial jurisdiction of a special court to take cognizance of a complaint under the Prevention of Money Laundering Act cannot be decided with reference to the place or places where any of the activities or process that constitute the offence under Section 3 took place, regardless of where the FIR related to the scheduled offence was filed and regardless of which court took cognizance of the scheduled offence. It was also observed that the special court PMLA does not lack territorial jurisdiction to hear the matter. In any case, a court's lack of jurisdiction to hear a complaint cannot be a reason to compel its transfer. The cognitive defect of the lack of jurisdiction, assuming it exists, benefits the accused and so does not need to be corrected at the accused's request to his detriment. Remarking that the matter became a source of embarrassment as the inadvertent mention of a lawyer's name as put mine in a court record went viral, the Supreme Court has concluded that the same was unintentional. A division bench of Justice Krishna Murari and Justice Sanjay Karol has closed the suo motu proceedings initiated to get to the bottom of the issue, and after the lawyer and advocate on record tendered an apology. The court remarked that the error in recording of the proceeding of the said date has caused a lot of embarrassment to the court, as the same has been widely circulated on WhatsApp and other social media. However, it considered the fact that the advocate on record is a young lawyer and has tendered an unqualified apology for the same. The Supreme Court, in a notable ruling, overturned detention order passed by the Delhi High Court. The court reflected that the preventive detention legislation is a remnant of colonialism and grants excessive authority to the government. These laws must be examined carefully as they have a potential to be misused by the authority, and any failure to adhere to the procedural requirement would accrue in favor of the detainee, a division bench of Justice Krishna Murari and Justice Ramasubramanian remarked. The court, while examining the difference between Preventive Detention Act and Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, clarified that the Pankaj Kumar judgment is applicable only to the detaining authority or the specially empowered officer under the Conservation Act, while the Abdullah Kunhi judgment is applicable only on the government, and concluded that there is no conflict between the two. Using the rule of harmonious construction, the court concluded that both the acts work in harmony with one another, and thus there is no need to refer the issue to a larger bench. The Supreme Court has referred to a 9-judge bench the issue of constitutional validity of GST on lease or rent payment in terms of Para 2 and Para 5A of Schedule 2 of the Central Goods and Services Act 2017 and Goa Goods and Services Act 2017. A division bench of Justice M.R. Shah and Justice Sanjay Karol tagged the SLP in matter of Myra Yash Hotel Private Limited versus Union of India with a civil appeal that is pending before the 9-judge bench. The contention is that under Article 246A of the Constitution of India, GST can be levied only on goods and services, and since leasing and renting don't fall in the category of services, the same cannot be levied on their payment. On this premises, it has been averred that the state government is empowered to tax transactions relating to the immovable property under entry 49 list 2nd of the 7th schedule of the Constitution of India, and therefore levying of the same under Article 246A is unlawful. The Bombay High Court has ruled that the service tax was enacted under the residuary power of legislation, and the ambit is such that the assumption of Parliament that there is a service element in the lease of land cannot be challenged as long as the tax does not come with the list 2nd of the 7th schedule. Next, we have Delhi High Court. The Delhi High Court has reiterated that the right of a convict to file an SLP against the dismissal of his criminal appeal is an essential one, and the same cannot be denied on the grounds that the free legal aid is available in the jail and SLP can be filed from the jail itself. The single judgment observed that it has been time and again held by courts that the right of a convict to file an SLP against the dismissal of his criminal appeal by a high court is an essential right, and the same could not be denied on the ground that the free legal aid was available in the jail and SLP could be filed from the jail itself. Since the only hope of the petitioner was from the apex court as far as the conviction was concerned, he must be provided with an opportunity to pursue his legal remedy by filing an SLP to the counsel of his choice. The Delhi High Court has held that the act of an appellant peering into the bathroom while a woman was taking bath, which regrettably only had a curtain at the entry instead of a door, would amount to an invasion of privacy and unquestionably constitute a violation of Section 354C of the Indian Penal Code. The single judgment referred to Section 354C of the IPC, which talked about voyeurism, a sex crime against women in India, by the Criminal Law Amendment Act 2013, and noted, as per explanation 1 to the Section 354C, which clarified that the meaning of private act, it would include an act of watching committed by the offender in a location used by a woman or a victim while she is performing a private act where she reasonably expects privacy and where her genitalia, posterior or breast are exposed or covered only by underwear, or while she is using the restroom, or while performing a sexual act and that is not typically performed in public and she reasonably expects that she would not be observed, or when she authorizes the taking of pictures or doing of any act but not the sharing of those things with others, and when the pictures or these things are shared. The Delhi High Court has held that landlords cannot recover possession of the tenanted premises if tenants didn't reveal issue that could be considered in court at the stage of defense. The bench referred to Abid ul Islam versus Inder Sen Dua and reiterated that the stage of seeking leave to defend, the tenant is required to disclose any fact that give rise to triable issues and warrant consideration on merits, and the landlady is barred from obtaining an order for the recovery of possession of the tenanted premises. Regarding respondent's ownership and existence of tenancy, it noted that it was a matter of a record that the subject property was mutated in the respondent's name and she was paying the house tax for the said property in her capacity as the owner of the property. After the death of her husband, the respondent's children executed a recorded release deed in her favor in 2001, making her the absolute owner of the subject property. The petitioner had not disputed these facts. As a result, it concluded that the trial court's finding on ownership and the existence of the landlord-tenant relationships were accurate, and the petitioner's pleading in the leave to defend and revision petitions were absurd. Now let's have an overview of other high courts. The Bombay High Court has held that transgenders who change their gender to female comes within the definition of a woman under the Domestic Violence Act. The single judgment of Justice Amit Borkar observed that the word woman in Section 2A is no more limited to the binary of women and men, includes the transgender persons also who has changed her sex in tune with her gender characteristics. The court observed that Section 2A of the Domestic Violence Act 2005 refers to a woman who has or has been in a domestic relationship with the respondent. Irrespective of whether such persons have undergone sex or reassignment surgery, including persons with intersex variations and other persons mentioned in the definition, Section 7 enables a person who has performed surgery to change gender to file an application with the district magistrate for change of such gender. Further, the court said that there is no manner of doubt that the transgender person or either a male or female who has performed the sex exchange operation are entitled to gender to their choice. It concluded that the person who has exercised the right to decide the self-identified gender of a woman is an aggrieved person within the meaning of Section 2A of the Domestic Violence Act 2005. The Himachal Pradesh High Court has held that it would be treading on thin ice if the courts were to venture into reviewing the decision of an expert who forms a part of the selection board, and it is not within the domain of the court to enter into the merits of a selection process. Only in case of malfeasance or violations of statutory rules can the court intervene. The court noted that the petitioner has not questioned the criteria formulated by the respondents or the award of marks. In fact, no reference has been made into the writ petition. The court then noted that it would be too late for the petitioners to contend that the award of marks for possessing additional qualification had no nexus for filing up the post of drawing master. If the petitioner was agreed, he should have assailed the same at the appropriate stage. Taking exception to public prosecutors expressing no objection to bail without the case diary being produced before the trial court, the Calcutta High Court has asserted that making statements contrary to the investigation cannot be made by him being representative of the state. The single judge bench of Justice Tiranthakar Ghosh remarked that while the public prosecutor may have an opinion, such opinion should not form the basis of a submission and moves in neglect to the material collected by the investigating officer. The court didn't approve of the public prosecutor giving no objection without the case diary being produced before the court and keeping the IO in doubt. Noting that the investigation of the case has already been completed and custody of the accused is not required, the court noted that the prayer of the cancellation of the bail as made before the court under the changed circumstances is not required to be interfered with. In a notable move, the Madhya Pradesh High Court has asked the Law Commission of India to suggest suitable amendments to the Protection of Children from Sexual Offences (POCSO) Act in order to empower special courts to impose correctional methods rather than imprisonment and do away with the minimum sentence in special circumstances. A single judge bench of Justice Atul Sridharan, while deciding a bail petition, stressed that POCSO doesn't make a distinction between rape without consent and statutory rape with consent but the victim is a minor, and thus asked for discretion to be provided to special judges in the following situations. A. When the prosecutrix is below the age of consent but de facto consent is apparent, not to have a minimum sentence and instead give the discretion to the special court, who is a senior sessions judge, usually with more than 20 years of judicial experience, to impose a sentence as per the facts and circumstances of the case, which can extend up to 20 years, and B. Where the prosecutrix is below the age of consent and the relationship has culminated into marriage with or without children, there should not be any sentence or of imprisonment, and instead the special court be empowered to impose alternate correctional methods like community services, etc. The court pointed out POCSO provisions in the case of statutory rape have the propensity of destroying families where the victim, usually on the cusp of majority, elopes with the accused, gets married, has children, and later the accused is put to trial and is convicted and sentenced to minimum of 10 years of rigorous imprisonment, which may extend to 20 years. He also recognized the helplessness that prevails in the courts, which even while being aware of the realities of the society, are forced to apply the will of the legislative as it is. The road to hell is indeed paved with good intention, the court said. Remarking that suppression or concealment of material facts is not advocacy but jugglery, manipulation, maneuvering or misrepresentation, the Jammu and Kashmir and Ladakh High Court has made it clear that the same has no place in equitable and prerogative jurisdiction. The division bench of Justice Sanjeev Kumar and Justice Puneet Gupta in this view upheld a single judge bench ruling imposing Rs 1 lakh penalty on the petitioner for suppressing material facts and misleading the court to gain an advantage over the other side. The court observed that litigant is bound to state all facts which are material or relevant to the litigation and must candidly state all the facts before the court without reservation. He cannot be permitted to play hide and seek and to pick and choose the facts which he likes to disclose and keep back or conceal other facts. Suppression of material facts, concealment of full details of litigation present and past between the parties to a subject matter of dispute, resolution or manipulation of relevant facts, misleading the court by stating false facts or withholding true facts, this entitle a party to invoke equitable jurisdiction under Article 226 of the Constitution of India, the court added. While setting aside the judgment of the trial court, the Orissa High Court has noted that no law has given the power or authority to the executive magistrate to record any confession for offences under the Essential Commodities Act, and in absence of the same, recording of confession by him is not admissible in the eyes of law. The court observed that since no law has given the power or authority to the executive magistrate to record confession, and in absence of any legal sanction, the recording of confession was held to have no admissibility in the eyes of law. It can be treated as an extrajudicial confession, but since there is no evidence that the accused gave it voluntarily, it loses its sanctity. The court held that the statement of the appellant accused should not have been utilized by the prosecution or relied upon by the trial court, thus making the impugned order bad in law to the extent. Further, the court noted that there was absolutely no material to show that the groundnuts allegedly found in the two houses belonged to the accused person, or that he was dealing with the same in any manner. Moving on to miscellaneous news. The Surat Sessions Court has rejected Rahul Gandhi's appeal while seeking a stay and suspension of the lower court order which convicted him in the 2019 defamation case and sentenced him to 2 years in jail. He has mentioned in the appeal that he was treated harshly by the judge, who even name-called him, and his statements has been misconceived. The Supreme Court E-Committee has conducted the first ever Digital Accessibility Information and Communications Technology ICT training for visually challenged judicial officers and court staff. The committee has planned to implement digital accessibility training for persons with disabilities in a phased manner for judges and court staff. Although the first leg of the training program addressed people with visual disabilities only, it will be extended to cover all categories of disabilities. CJI Chandrachud, the chairperson of the E-Committee, attended the session and interacted with the participants from various parts of the country to get their suggestion and feedback on the training. In a letter, he has also encouraged all high courts to make the digital infrastructure accessible to all the conformity with the Constitution and statutory entitlements of persons with disabilities. He also planned out a series of structural interventions for them to undertake to enhance digital accessibility. In a major development, the Supreme Court has directed the formation of a grievance redressal committee at the High Court level to take up grievances of lawyers on strike. A division bench of Justice M.R. Shah and Justice Ehsanuddin Alamullah in the matter of District Bar Association Dehradun versus Ishwar Shandalya and others opined that the time and again strikes by Bar Association has resulted in the disruption of judicial functioning, and there should be a forum to which they can ventilate their genuine grievances. The direction came in a case concerning the practice of strikes and boycotting of courts being called for by the District Bar Association of Uttarakhand every working Saturday. Former Chief Justice of India N.V. Ramana has said that a shift in the mindset of the public to opt for mediation is one of the biggest challenges in the field, and nudged legal practitioners to suggest mediation as an effective mode of dispute resolution. Speaking at India's first Indian Mediation Day organized by the International Arbitration and Mediation Centre, Justice Ramana emphasized that the ability of resolving dispute at a faster pace will help the growth of the society, country, nation and world. Noting that the world today has realized arbitration and mediation are one of the most powerful tools to resolve disputes, the retired judge said that the power of mediation is understated and has deep roots in the society. The Kerala High Court has observed that an application seeking time-bound disposal of a matter cannot be dismissed without fixing a time frame for the same. The division bench of Justice Anil K. Narendran and Justice P.G. Ajit Kumar took exception to one family court order wherein it disposed of such an application, passing an order that the case will be disposed at the earliest. The court remarked that if the applicant has provided a valid or justifiable reason, the court is bound to order disposal of a specific time limit. Speaking at the national seminar on the topic mediation at the dawn of a golden age, the Attorney General of India R. Venkataramani proposed setting up of a National Council of Mediators Watch and National Awards for Mediators' accomplishments. In the council, he suggested advocate generals from all different states and senior members of bar to be involved. The event was organized by the Delhi High Court Mediation and Conciliation Centre, Samadhan, under the aegis of National Legal Services Authority and Mediation and Conciliation Project Committee. The Attorney General announced that he is keen to further the expansion of the mediation regime in the country and therefore shall push the two above-mentioned agendas to his best in his short tenure. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.